Hello and welcome on board to this mini teach-in session. This is one of a series of teach-in sessions that we've put together for members and for others. It's available on our YouTube channel along with all our other teach-in videos and also our videos of our webinar program, which we've been running for the past few years. And these teach-in videos are meant just to highlight key points that are relevant to tenant farmers on a range of topical issues. And today we are looking at the issue of what can I do if my landlord won't give me consent to expand my slurry storage capacity. That's a very topical situation with the pollution control regulations that are in Wales and in England. We've had a webinar on this with the catchment sensitive farming people, which you can go back and look at within our YouTube channel. And I'm delighted today to say that we've got one of our expert rural surveyors with us who's going to lead us through that topic in a moment, Kathleen Walton. But I should say that we're really chuffed that our webinar series and our teach-in series is being sponsored this year by Oxbury Bank. Oxbury Bank is a new kid on the block. They were formed and launched in 2021, and they are the only bank that's dedicated to agriculture and food production. So we're really pleased and delighted to have Oxbury on board sponsoring our series for this year. I should say that this is being recorded at the beginning of 2023, so any information that we give or provide is relevant at that point, and please check back in with us for any changes that have taken place since that time. But without further ado, I'm going to ask Kathleen to present to us on this topical issue. Thanks, Kathleen.
Thank you, George. Much appreciated. So I'm just going to dive straight in on the question of what can I do if my landlord won't give me consent to expand my slurry store. But before I do that, I think that it's important to set the scene about what slurry storage do I need and whether it's your responsibility to provide it. So what is slurry and what can we do in order to store it? So it can either be manure direct from livestock while in the yard or building, or a pumpable mixture of livestock excreta, bedding, rainwater, washings from buildings or yards used by livestock. So here you can see is a little bit of the summary of the regulations which apply to slurry storage in particular and where it takes effect. So for instance, the SAFO regulations apply to all farmers in England and Wales. And as an absolute minimum, you will be required to have 4 months storage if you create slurry. For those of you in an MVZ area, then you will need to have 5 or 6 months. And as George quite rightly pointed out, the new control of agri-pollution regulations in Wales means that from the 1st of August that all farmers in Wales will need to have either 5 or 6 months storage. Now, SAFO regulations at the moment takes into account that any structures prior to 1991, should they not be creating pollution, means that you might be exempt at the moment, but if you're in Wales, that will no longer be the case from the 1st of August 2024. It's highly likely that if you're in an MVZ area, you will know that, but if you don't, then you can check the DEFRA Magic Map, which is, if you Google it, DEFRA Magic Map, it will pop up. And the next thing you want to do is to find out whether or not you've actually got enough storage capacity. So how do you know that? You can use something like the AHDB Slurry Wizard. Again, if you Google it, it will pop right up. And what you'll need to input into that will be dimensions of the current stores, clean and dirty water volumes, entering stores, including your parlour washings, or whether you use a separator and other things like your age and class of the animals on your holding. So whose responsibility is it to provide enough slurry storage capacity? Well, as it says on the screen, before you do anything, the best thing to do is to check your tenancy agreement. If you're not confident about checking your tenancy agreement, you can send that into the TFA and one of the advisors can do that for you, just so that you're absolutely on board with whose responsibility it is to provide the necessary fixed equipment to comply with statutory regulations. So if you're in an Agricultural Holdings Act tenancy, if you've got one of those, then the statutory fallback is that it's the landlord's responsibility to do that. However, your tenancy agreement may have transferred that to you, so you need to check that. And for those of you with a farm business tenancy, unfortunately, the answer to that does absolutely depend on what is in your tenancy agreement. There is no statutory fallback. And another word of warning for these is that if you're entering into a new agreement, do watch out for this, because it could be costly if you don't notice and then sign away the responsibility of the landlord to provide that fixed equipment. So now that we've established how much you need and whose responsibility it is, what can I do if the landlord won't provide me consent to expand your slurry store? Well, it very much depends on whether or not, again, you have an Agricultural Holding Act tenancy or a farm business tenancy. If you have an Agricultural Holding Act tenancy, you do have some statutory remedies. So under this, you could make a written request for consent to the landlord to expand the slurry store. And if they do not decide that they are happy to comply with that, you could refer the matter to tribunal under Section 19A of the Agricultural Holding Act. Or you could apply under Section 67, which is the ability to get compensation for a long-term improvement. However, there is no statutory fallback under farm business tenancies. If you want to know more information about this, then as George quite rightly said earlier on, there is a webinar on the subject, and there is also a member exclusive blog on this particular subject. So you can find out more information on the TFA website, or indeed, if you wish to have a chat to somebody about it, you can talk to a TFA advisor at a later date.
Okay, thanks, Kathleen. That's a really good overview of where we are and the sort of information that our members need to be thinking about as they consider slurry storage and compliance with the new regulations. And obviously, we're getting lots of questions to us on these issues. And I'll just throw a couple at you that we quite often get from members just to highlight some of the issues. So, where I've looked at my agreement, and I can see that it is the landlord's responsibility to ensure that I'm compliant with the regulations, and I'm on an Agricultural Holdings Act tenancy. So what happens if my farm business includes other land in addition, perhaps rented on an FBT, maybe even from the same landlord, or a tenancy from another landlord, or land that I own? What do I do about compliance issues in that scenario?
Okay. So regardless of whether you own or let land elsewhere, your landlord would only be responsible for providing the fixed equipment necessary to comply with statutory requirements for the agricultural holding that is comprised in the contract of tenancy. It does not include any other land, whether it's under that same landlord or not. And this land would, because it wouldn't fall under that same contract of tenancy. If you farm the land together, it may be that you keep more animals as a result of the additional land. If this is the case and you need additional storage because of it, it would be your responsibility to provide that additional element. So if more storage is needed and it's required statutorily, you could request consent from the landlord for that additional storage to be treated as eligible for compensation at the end of the tenancy. If your landlord refuses to do that, or you're unhappy with the terms, that you could apply to the tribunal under Section 67 of the Act for their approval to carry out the improvement and to agree the compensation.
Okay, I think that's clear then. So I might have some responsibility over and above the land that I'm actually letting from my landlord. Now, assuming that it's my responsibility to comply with these new standards or these regulatory standards, is it guaranteed that I will get compensation for any investment that I make into providing that fixed equipment? And how do you take into consideration the way grant aid is covered?
Yes, so there's no guarantee that you would be offered compensation by your landlord if you're responsible for providing the fixed equipment necessary to comply with statutory regulations, or even if compensation is offered, that'll be on agreeable terms. Any compensation received would be proportionately reduced to account for any grant aid received for the improvement. So if you got a slurry infrastructure grant, for example, then any compensation would be reduced accordingly to the grant that you received. If you have an Agricultural Holding Act tenancy, you could provide the equipment required as a tenant's fixture if you weren't given that and offered it to the landlord at the end of the tenancy. There is a risk that the landlord will not agree to take to the fixture, which would mean that the fixture would need to be removed and the land made good, which could be or would be expensive. Alternatively, you could apply to the tribunal, as I said earlier on, under Section 67 for their approval to carry out the improvement and to agree the level of compensation. If you have a farm business tenancy, you're not able to offer tenants fixtures to the landlord in the same way as you do under an AHA. However, you could remove it without notice, subject to conditions. For treatment of compensation, for tenants' improvements and dispute resolution, where there is no agreement, you should check your tenancy agreement. Unfortunately, there's no statutory remedy for tenants with an FBT to refer disputes related to compensation.
Okay, thanks, Kathleen. Lots of food for thought there. I think we'll need to leave it there for now. We've probably raised more questions than answers for people, but obviously people can ring in or contact us if they're members of the TFA for advice on this specifically. Membership of the TFA is relatively inexpensive. At the moment, it's only £249 per year, and for that you get dedicated information, advice, and support from expert advisors and surveyors like Kathleen. So I hope everybody has enjoyed this brief introduction. It is part of a wider video library, as I've said, available on our YouTube channel, the Tenant Farmers YouTube channel. To join the TFA, you can just go to our website or you can call us at any time. Thanks again to Oxbury Bank for their generous sponsorship of this series of teach-ins and webinars. And watch out for future webinars that we are having. If you're watching this at the beginning of 2023, we're hoping to have the DEFRA program director for the Agricultural Transition Plan back with us in February to talk about some of the changes that have recently been announced by the government in terms of ELM and the Sustainable Farming Incentive, and also the new Countryside Stewardship Plus. And we'll be looking a bit later in the year at whether and how and what schemes are available to you and which ones will be most suitable for you. But for now, thanks very much for joining us, and come back to us soon.